Welcome back to this final segment of this four-part session in relation to sources of the Constitution, and in particular we were considering just before the break the idea of royal prerogative. As I said before the break, there's a whole law session on that area, and so we're just doing it in relation to this particular area. Now, as I said before the break, when you look at the idea of the royal prerogative, it talks about these powers that the crown exercise, of course, through cabinet ministers. The point is that when you look at these prerogative powers in the context of conventions, what does it mean? Now, there's been a whole side of discussion in relation to the merits, demerits, practicability of placing the prerogative powers on a statutory footing. Now, we've seen that all this talk seemed to have culminated in the Constitutional Reform and Governance Act, but that various things were left out. Again, I would refer you back to the royal prerogative law session. But the point for us is, when you look at the royal prerogative in the context of conventions, you need to consider the workings of the cabinet system. So how do conventions work when you look at prerogative powers? Well, the giving of the royal assent to legislation. No bill has the force of law until the Queen gives her assent. So legally, the Queen can withhold power. But by convention, what we see is that as long as it's gone through both houses, then she will. That's the convention. The Queen should act upon the advice of ministers, and in particular should dissolve Parliament on the advice of the Prime Minister. That's the convention. But again, the solution has been put on a statutory footing, but by way of historical example. The point is, legally, she could do what she likes, but by convention, this is how it is exercised. Now, again, the monarch may decide who will be the next prime minister, but by convention, the monarch invites the leader of the party or group commanding a majority of the House of Commons to form the government. And of course, the monarch, by convention, must appoint as her ministers such persons as the prime minister advises. By law, the monarch can appoint and dismiss ministers at his or her pleasure. Now, the office of prime minister as well is a creature of convention. There is no law which requires that a prime minister be appointed, or there is no law which specifies how one is to be chosen. The cabinet is also a product of convention. The government is entitled to continue in office only so long as it enjoys the confidence of a majority of the House. And of course, we see that collective and individual ministerial responsibility, those are also have conventional issues in relation to how they are supposed to be exercised. Now let's consider also conventions in relation to the regulation and the relations between the House of Lords and the House of Commons, as well as proceedings in Parliament. Well, what are some of these examples? Well, if the government loses the support in the House of Commons and is defeated in a vote of confidence, the Prime Minister should advise the monarch to dissolve Parliament. Now, in the case of conflict, the Lords should ultimately yield to the Commons. The Parliament Acts of 1911 and 1949 have largely rendered this convention unnecessary because, again, there's going to be some conflict, there's going to be some tension. We see that there have been tensions in the past, and now we see that when it comes to money bills, for example, we see that this is not the remit of the Lords. But certainly we see that by convention, the House with the strength, as it were, is the House of Commons, because it is a directly elected House. But do consider the role of a reformed House of Lords. Now, in a later law session, of course, we will consider House of Lords reform. They've been reforming the House of Lords since the early 20th century. It's been in reform since forever. The preamble to the 1911 Act talks about reform of the House of Lords. The point here, of course, is that if you've got a reformed House of Lords, will this convention of the Lords yielding to the Commons still stand? When you look at proposals for the expenditure of public money to be introduced in the House of Commons is the convention. tends to be not within the remit of the House of Lords. The arranging of the House of Commons business between the Prime Minister or leader of the House and the leader of the opposition is by convention the way that things are done. It is not done from an outside point of view. And of course, by convention, the Speaker sees fair play in relation to debates. Now, as we go into conventions which regulate the relations between the UK and other members of the Commonwealth, we see, for example, that the Queen, in appointing Governor General of an independent Commonwealth country, acts on the advice of the Minister, the Prime Minister rather, of that particular country. And the Governor General is the representative of the Queen, not the British government, rather the Queen. Now, what are the purposes? What is the purpose of constitutional conventions? Well, conventions are the means of bringing about certain types of constitutional development without formal changes in the law. It is this flexibility which makes it terribly attractive, but of course which makes it somewhat unattractive. Now, since 1688, the power of the executive has effectively been transferred from the sovereign to ministers responsible to Parliament, and this has been achieved largely by the growth of conventional limitations on the royal prerogative, because in law, the power of the executive government is still vested in the Crown, albeit that by convention it is carried out by the ministers. So that when you look at the whole system of cabinet government, it actually rests upon rules of practice which have absolutely no legal force. And Professor Monroe talks about this in his book. And because that's the point. When you look at how the UK is governed, it is by procedural rules which have no legal force whatsoever. So it begs the question, why are they observed? Well, the Supreme Court of Canada has said that the main purpose of conventions is to ensure that the legal framework of the Constitution is operated in accordance with prevailing constitutional values of the period. That is one of the good things about conventions. The conventions allow, rather than a rigid, staid approach to looking at how the workings among the three organs of the state should be, the conventions allow for flexibility according to the values in relation to that time. So if we take you back to, for example, the case of reamendment of the Constitution of the Reamendment Constitution of Canada, this certainly bears this out. Well, when you look at this then, conventions are observed for the positive reason that they express prevailing constitutional values, and for the negative reason of avoiding the difficulties that may then follow on from an unconstitutional conduct. When we look on the rare occasions when courts have been asked to enforce conventions, they have refused, but courts do recognize their existence. Consider Attorney General and Jonathan Cape, and also Liversidge, and certainly Mazimba Muto that we have looked at before. Now, what about conventions becoming law? These are non-legal rules, but as you have seen, these are important, significant rules which deal with the workings of a democracy, of a country, of a jurisdiction. Well, conventions can only be converted into legal rules by the process of legislation. So when you look at Section 4 of the Statute of Westminster, 1931, for example, we see how we can move these conventions into a legal rule. I would also point you to the Parliament Act 1911, which enacted following a breach of convention, and we also see that devolution legislation will also put into legal force some conventional matters. Now, is there an argument for codifying or putting into legislative form conventions? Well, there is the argument by De Smith that it would certainly purchase certainty at the expense of flexibility. Because what would it do? It would make it certain, but that would not necessarily make it flexible. Judicial enforcement would also not be suitable for conventions concerning political relationships, for example, when you look at ministerial responsibility. And certainly when you look at conventions, they tend to have that adaptable air about them. And certainly that is one of the things, as I keep saying, that makes them attractive. The point, though, that conventions are not necessarily just a creature of the UK. I want you to be very aware that conventions do exist in countries with written constitutions. They may very well exist if you are in a jurisdiction outside the UK, because generally the constitution is written, or a constitution is written, in such broad terms that there needs to be some rules, some basis as to how this actually operates in practice. And so certainly these non-legal rules may very well go some way towards assisting how even a codified constitution is considered. This, of course, brings us to the end of Sources of the Constitution, and I would certainly ask you to join me when we go into another law session, which of course will deal with the government and House of Commons and what happens in Parliament.